if you give me I need 100 sets of 100 pairs of some dress, cultural attire, okay, some dress for some school function. So if you are able to give it before 10th of this month, I will make the payment. Otherwise, there will be no payment. Okay, so those are one form. Those are like, that is an example of contingency. So contingent contract is where upon happening or non-happening of a future uncertain event. So not this. Here the event is in control. So it is depending upon the tailor. If the tailor is having more employees he is keeping, and if he is working and completing the work within the stipulated time, then it is in his own control. But some things may not be in your control. So those are contingent contracts. Like if someone dies, I will give you something that is not in your control. Okay, or if it rains, I will give you have to pay something. Your insurance contracts. Let us say you have taken fire insurance for the house. So if your house is damaged by fire, then the insurance company will give you compensation. So that is future uncertain event, and it is not in control of either of the parties. If you only burn your house, then insurance will not be given. Okay. Similarly, life insurance.
Unseen also. Chapter future unseen also.
Future uncertain events.
Uncertain also.
Uncertain only. We don't know. Uncertain means outada oda manaku teliyadu. So we don't know. Now we don't know whether your house will be damaged by fire or not. That is, and it is future, and it is uncertain. Okay, future uncertain event. So life insurance policy, future uncertain event. You don't know when you will die. Accident insurance, motor vehicle accident, we take insurance. Okay, so these are all examples of contingent contracts. Then performance of contracts. So there are different modes in which a contract may be discharged or performance may be done. So what are those, and when the parties may be held liable, so for non-performance, etc., we will be discussing in this chapter. Then you have chapter 5, which deals with certain relations resembling those created by contract. So here there is no actual contract. So like under chapter 2, valid contract is given. So like in that sense there is no contract, but there are relations which are resembling of a contract. So which look like contract, but it is not contract. So those are, we generally refer to them as quasi-contracts. Quasi-contracts or quasi-contracts you call them. So like finder of lost goods is there, or supplying of necessities to a minor is there. So those types of things come under quasi-contracts. So we will be discussing the different types of such contracts. Then you have chapter 6 dealing with consequences of breach of contract. Now what do you mean by breach of contract? When either of the parties to the contract does not perform his or her obligations under the contract, it amounts to breach of contract. Okay, if you are willfully not doing anything, or willfully or even otherwise if you are not doing something, then it amounts to breach of contract. What would be the consequences? So in civil, because it is a civil law, so the remedy is also civil remedy, that is in the nature of damages. So different types of damages are there. So those things are discussed under section 73 to 75. Then you have chapter 8, which deals with indemnity and guarantee. So what do you mean by indemnity? What is the contract of indemnity? Who are the parties? You have the indemnifier and the indemnified. Okay, so what do you mean by it? And then in guarantee. So in guarantee you have principal debtor, a creditor and a guarantor or surety. So I gave you 1 lakh rupees loan, some other person gave surety. So what is his liability? If I don't pay, he will pay, right? So that is, so what is his liability and what are the roles and duties of each of the parties is discussed here. Then bailment. So chapter 9 deals with bailment. So this bailment is not bail. So that bail in criminal law is different. This is bailment. So bailment means where the goods are delivered with a specific purpose to a party and they have to be returned to the owner after that purpose is done. That is, such type of contracts come under contract of bailment. You gave your watch for repair. Okay. Now that technician, he kept the watch with him. He said, okay, tomorrow you come and take. It will take time to repair. So now he has the possession of it. So whether he can sell it, he can sell your watch? No. So he has to keep it in his custody and he has to do that specified task which is given to him. That is, he has to repair and he has to return. However, if you don't pay the amount of his services, for his services, whatever is agreed, his service charge will be there, no? For repairing you have to give him money. So that if you don't pay, then he can withhold and he can keep it. That is called as a right of lien. So he can keep the watch with him and only when you pay the amount he will return it to him. So that is bailment. Then agency. Agency is where you are employing some other person or appointing some person to act on behalf of you for some reasons. Okay. So that is agency. So we will be discussing with all these aspects in our classes. So now let us go to the Bear Act.
Sir, agency is related to power of attorney.
Yes, correct. It is related to power of attorney. There is a separate power of attorney act also. That is different. Here agency, it includes power of attorney act, but it is not only restricted to that. It is more wider. Yes. Now, as I told you, this is the short title, that is the Indian Contract Act 1872, whereas it is expedient to define and amend certain parts of law relating to contracts. So, then it is hereby enacted as follows. So, short title is Indian Contract Act 1872. Then it extends to whole of India. Earlier there was no Jammu Kashmir, now Article 371 is removed. So, Jammu and Kashmir is also there. Now here saving is given, exception like, so nothing here in content shall affect the provisions of any statute, act or regulation not hereby expressly repealed, nor any usage or custom of trade, nor any incident of any contract not inconsistent with provisions of this act. So here, because at that time, so when this act was made, so the savings was introduced subsequently, you can see here. So in 1914, the savings was introduced. Okay. So however, at that time, what was, so there were so many traditional practices, usages which were there. So which may not have found specific recognition under the Indian Contract Act. So whatever is not inconsistent means contrary to, or which is against the provisions of Indian Contract Act, thus those aspects will also be valid. It will not affect it. The Indian Contract Act will not affect it. Then in section 2 we have the interpretation clause. So in this act the following words and expressions are used in the following senses unless a contrary intention appears from the context. So it is nothing but like the definition clause. Okay.
What is the difference between interpretation and definition clause?
So actually there is no difference, Shantanu. So at that time the interpretation clause was used. So here you have to interpret these words in the sense they have been used. So here there are no, if you see the way in which it is mentioned, the specific terms are not defined. Okay, so but interpretation, how this has to be interpreted, that is given. So if you see section 2a, okay, for instance, section 2a is actually the definition for proposal or offer, proposal. So but here it is not defined like proposal means. So it is written in another way, that's all. So technically there is not much difference. So section 2a defines proposal. So when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of the other. This is number 3. Such act or abstinence, he is said to make a proposal. So what does it mean? So proposal is nothing but offer. So when any person signifies to another, that is signifies his willingness to other. Willingness means his approval or his desire that he is intending to do, or abstain means not do something. Abstain means not to do. Okay, abstain means not to do. So now let us say I will draw your painting. Okay, so I am telling you I will draw your painting. You give me 100 rupees. So here we are keeping aside the 100 rupees. You give me 100 rupees, etc. We are keeping it aside. So I am saying I will draw your painting and you give me 100 rupees. So what I am intending to do here, I want you to say yes. Okay, so with an intention to obtaining the assent. Assent means yes. Assent means yes. Assent of the other. Now you may have visited Koti here, or whenever you may have gone to some street hawkers, right? Street hawkers means who sell on the footpath. So what do those people do? They will be selling, let us say they will be selling some toys or some day-to-day household articles, which like some fans, small fans, or books, pencil, paper, pen, cap, umbrella, something like that. So what such person will tell you? Oh, 100 rupees, take this, 100 rupees, take this, please buy 100 rupees, please buy 100 rupees. So that is proposal. So where you are willing to do, so he is willing to give it to you. Okay, willingness to do or abstain from doing anything with a view of obtaining the assent of the other. So he wants your yes. Okay, so similarly you ask you want to have clean your house, or you want to paint your house. Okay, now you have asked so many painters. So one painter has come and he told you, I will paint your house, give me 50,000 rupees. So he is willing to do something and he wants your assent. So that is called offer. Similarly, abstain from doing something may also be there. So abstain means not doing something. That can also be like offer. So if you give me now you have some business, like you have fast food business, okay, and some other person also is setting up fast food in the same street. So you have fast food business, and other person also wants to set up fast food business in the same street. Now he can have his own business also, you cannot stop him. So however, you said you asked him, why are you doing here? So he said, if you give me 1 lakh rupees, I will not do business in the same street. So for not doing something, he is asking some money and he wants your assent for that. So that is also proposal. So proposal can be for doing something or not doing something also.
That is non-competing clause, sir.
Yes. So when the person to whom the proposal is made signifies his assent thereto. So the person to whom proposal is made signifies his assent. Assent means yes. Assent thereto. The proposal is said to be accepted. A proposal, when accepted, becomes a promise. Okay. So now I told you someone offered to paint your house for 50,000 rupees. You said okay. So what you are doing here? So you are giving your assent. So when the person to whom the proposal is made, so painter made proposal to you. You said yes, you gave assent, that is yes, and the proposal is said to be accepted. So once the proposal is accepted, it becomes promise. Okay.